Good morning and good afternoon to everybody. My name is Kishore and I'm the event manager with Compliance Scheme Corporation and would be your today's host. Thank you everyone for joining in today's live webinar, Relation in the Workplace, what it looks like and how to avoid it. Today's presenter is Michael D. Haberman. I will quickly introduce Mike. Mike is a consultant, speaker, writer and teacher. He is co-founder of Omega HR Solutions Inc. Mike brings years of experience in dealing with challenges of human resources in the 21st century. He has a master's in HR and certified as a senior HR professional. Mike is the author of Human Resource Pro, founder of OmegaSolutions.com. He has also been named as a top digital influencer in human resource. Now, before I hand over to Mike, I should inform you that the session would be of 60 minutes. Also, we have Q&A session at the end of the webinar. You can keep sending your questions through chat window, and Michael will answer those questions at the end. We will begin now. Michael, I would request you to please start the presentation.
Thank you, Kishore. And good day to everyone. Glad you could join us. We're going to talk about a subject which is becoming more and more prevalent all the time, and that is retaliation in the workplace from the standpoint of employers being accused of retaliating against their employees for actions that the employee has taken in conjunction with a claim of discrimination or a claim of claim of discrimination in a number of different areas. So what we're going to take a look at today is what is the definition of retaliation, talk a little bit about the rise of retaliation claims in today's business world. We'll discuss the various forms retaliation can take, what are some of the important components of that retaliation. I'm going to teach you how to prevent retaliation claims in the first place, what you need to do as far as document the claims of discrimination, and then we'll talk a little bit about how you go about investigating claims. So with that, let's go ahead and jump into a definition of retaliation. There's actually a distinction between whistleblowing and retaliation. There are a lot of laws that have a whistleblowing component to that, which protects the employee or helps the employee protect the public interest in revealing specific prohibited conduct where the company or the organization is wasting money, it is endangering public safety, it's violating public trust, and it's all about perhaps an honest, accountable government. Whistleblower complaints seldom include an employer's retaliation for complaints about personal dislikes or issues that affect only a single person. It is really a whistleblower is complaining about the company's behavior in relationship to the public or the government. It is as an example, OSHA has a whistleblower, Sarbanes-Oxley has a whistleblower provision to that, and in many cases, you, the employer, may not understand or really even know who has blown the whistle on you. Sarbanes-Oxley is one that has to deal with public companies, and it is somebody can blow the whistle on the company for a waste of taxpayers' dollars. In many cases, there's a reward for them doing so. But there are other laws, such as OSHA, such as wage and hour, such as EEOC, that companies or that employees can also blow the whistle on. And in many cases, it cannot be done secretly, as it can be done in the Sarbanes-Oxley. And in many cases, that whistleblowing is basically a notification to the government that somebody is engaging in workplace discrimination. So retaliation in that particular case deals with the laws that guarantee workers have individual rights where they can work free of discrimination, that they're getting paid minimum wage, that their rights as far as a union are being concerned. Those are all the laws that have a retaliation component in them. And those laws say that if an employer interferes with those rights in an illegal way, then the individual can bring a retaliation claim to protect themselves for their individual rights in connection with a complaint that they have made about that employer. So there is a difference between whistleblowing and retaliation. Whistleblowing is just basically a reporting to the government. Retaliation is something that the employer is doing against the employee for them having reported wrongdoing by the employer. As I mentioned earlier, almost all federal laws have some whistleblower provision to them. And the EEOC in particular has a retaliation provision, as does the Fair Labor Standards Act and all of the Department of Labor controlled laws prohibit employers from retaliating against their employers or their employees for a report of an activity that the employer is engaged in. OSHA is the organization that is charged with investigating complaints, and they cover 23 different laws, including the Sarbanes-Oxley law, and they're the ones that actually perform the investigation of any complaint. The laws will vary 30 days to 180 days, and actually even up to 300 days in the cases of the EEOC in some particular states for an employee to be able to file a complaint against the company for some violation of the law. Now, human resources, typically what we're talking about, the more common ones we talk about are ones that claim discrimination on the basis of some protected category, and typically in violation of the Civil Rights Act of 1964 and the amendments that come after that, so that we know that people, that it's common, the common terminology is the discrimination law. It is protection on basis of race, creed, color, sex, national origin, age, military service, genetics, and those protections under the EEOC, but it also comes in terms of wage and hour violations, of somebody reporting an employer to the government for not properly paying overtime, and then the employer retaliating against them. So that's, it is ultimately, there will be an investigation on a claim of retaliation. I want to, in particular, focus today's presentation on the Civil Rights Act claims. It is the #1 claim filed with the EEOC. It is, most people think it's race, or most people think it's age or sex discrimination. Those actually all fall short of the number of claims that are made against employers for an act of retaliation. It makes up 43% of the claims that are filed, and it is typically a claim that is made in conjunction with a claim of discrimination, so that if an employee goes and charges you with discrimination against them on the basis of their sex, typically their employer, or not their employer, but their lawyer, in helping them file a claim of discrimination on the basis of sex, will also then typically throw into there a claim of retaliation if there is some act that their lawyer has been able to claim was due to them having filed that claim of sex discrimination. And as you can see, retaliation claims, are evenly distributed or widely distributed among the various protected categories. Typically with race, when there's a race discrimination claim, 35% of the retaliation claims will have to do with race. And sex is fairly high up there. Age, disability are all up there, even down to GINA, which is the Genetic Information Non-Discrimination Act. People have filed retaliation claims on the basis of actions that were taken against them for their claim of genetic discrimination. So it's a wide claim. It is varied and usually attached to a claim of discrimination. I wanted to point out that a valid claim of retaliation does not require a valid claim of discrimination. And what that means is the fact that somebody may claim that you have discriminated against them on the basis of some protected category. They may go through and the EEOC may investigate or it may end up going to a court where there is an investigation of that claim of discrimination, and in turn the court or the EEOC says, nope, there is no evidence of any claim of discrimination in this particular case. That, however, if you took some retaliation against the employee for having filed that claim, the fact that that discrimination claim is dismissed does not automatically dismiss that claim of retaliation. You can still have a claim of retaliation against you for actions that you took on the basis of the fact that somebody did file a claim. You may have, somebody may have filed a claim of sexual harassment against an employer, and they investigate and they find that there was no sexual harassment that occurred. But in the meantime, the manager who had that claim of sexual harassment filed against him or her takes action against the employee by demoting them or firing them, or, as we'll see, a number of other situations where they've taken some substantial job action against them, such as a transfer, on the basis of the fact that that person filed a claim of sexual harassment against them. And even though the sexual harassment case is not upheld, you, the employer, can still be found guilty of retaliation, even though there was no valid claim of discrimination. So you've got to be very guarded in taking action against employees for filing claims of discrimination, because you can still be found guilty of retaliating against them. There is a formula that the EEOC has for retaliation, and I think this is would actually hold for Department of Labor actions as well. Wage violations, and there is in OSHA. And the formula is that if an employer takes an adverse employment action and it's against a covered individual who is engaged in protected category, then they deem that you retaliated against that particular employee. So let's explore some of the definitions of some of these terms. Who is a covered individual? Well, a covered individual is any employee or applicant who opposed a discriminatory practice. The fact that somebody didn't hire them because of their age. Somebody didn't hire them because of their race. Somebody didn't promote them because of their age. Somebody didn't promote them because of a claim of sexual harassment. All of those things that makes a person that a covered individual, where they have either had a charge, where they testified against somebody, or they participated in any manner in an investigation or a hearing, employers have been found to discriminate or retaliate against those employees. When somebody testifies against a manager, there may be consequences that that person that has testified will suffer from that manager. Or the fact that they're the individual that filed the complaint. They end up getting transferred, they end up getting fired, they end up getting demoted, they end up being denied opportunities. All of those things are what defines a covered individual. Anybody that has participated in those kinds of things who ends up suffering some action as a result of that is a covered individual. It does not have to be the person that is filing the claim. And it doesn't have to be, and it doesn't even have to involve filing the complaint. Just somebody who comes up and says to a supervisor, hey, I think what you're doing to Benny over there is unfair. And then as a result of that, the person who made that statement suffers some consequence in employment. As a result of that, they have a claim of retaliation. It can be somebody who's associated with another covered individual. And in that particular example, you have an employee who is who has claimed discrimination, and then there's another employee that they have their spouse that's working with them, or they have a close friend that's working with them, and the supervisor who has been claimed to have made a discriminatory act then takes action against not only the person who made the complaint, but also somebody associated with him. And actually, one case in particular that I can recall was that there was somebody who was being discriminated against because of their country of origin. And the person's spouse also worked at the company. Now, she was not involved in the complaint. She was not involved in any of the act of discrimination. Nobody took any action against her. But as a threat to the employee who was making the complaint, the manager or the supervisor had said that you go ahead and make this complaint, your wife is going to be out of a job. And in that particular case, not only was the employee able to claim retaliation for the response to their filing a complaint, but the spouse was also able to file a claim of retaliation, even though she hadn't actually ever been involved in the initial discrimination. So it is a matter of, by association, she was covered with a protection from retaliation, even though she had never really been involved in the first case. And then lastly, you could have someone who has filed a complaint at another employer who, because of a relationship with that particular employer, in this particular case it was somebody who had filed a complaint with a previous employer, had left, had gone to work, and the other employer had a relationship with their new employer and ended up being able to get them demoted or fired at their new job. They were able to claim retaliation both against their first employer and also their new employer on the basis of that particular action. So you've got to be very careful with what you do. And where I can think that coming into effect is quite often, particularly in smaller communities or in small industries, when you go and you file or do a background check on a new prospective employee or on a new employee, and you're checking with the previous employer, and that previous employer tells you that they would not rehire that individual, that employee had done them wrong, had filed claims of discrimination, and the new employer ends up either not hiring or as a result of that action ends up losing a job that they already had, then they can file claims against both employers for retaliation. So even in the reference checking process, you have to be somewhat guarded. The adverse action is for somebody to be able to claim that retaliation has occurred. They have to be able to demonstrate that their employer took an adverse action against them, and that means that they were demoted, they were kept from a promotion, they didn't get an increase. Any of those things that fall into the category of an adverse action against them can be claimed as retaliation if it is joined with the action that of them having made a claim. So what this means is that a reasonable employee, in looking at an action that an employer took to dissuade them from pursuing a claim of discrimination, if you've got an employer who is sitting there and having a conversation or threatening an employee that if you file this, this is going to reflect poorly on your performance evaluation, all of that can be considered to be an adverse action and an example of retaliation that they'll be able to take to the court and claim was an adverse action against them in their employment. There are some protection, everything I've said so far makes this sound like the deck is stacked against the employer. But there are some protections against, that are provided to, against employees and provided to employers that things that occur in the workplace, petty slights, minor annoyances, things that are said in some cases that occur all the time in the workplace, and as it says here, in all employees' experiences, won't necessarily be seen by the courts as being retaliation. The retaliation does have to be connected to an adverse action in their employment, and as a result of that, just the fact that they don't get along with somebody is not an act of retaliation. Just the fact that I'm not necessarily nice to you as an employee anymore doesn't mean that I am retaliating against you. That not being nice to you would have to be connected to an adverse action against you, in that my not being nice is now connected to you not getting the shift that you want to have, not getting the promotion you want to have, not getting the choice assignments that you would like to have. If you can connect those to my not being nice to you, then you have a claim of potential claim of retaliation. But if it's just the fact that you and I don't get along, but we still work together, you still can get promoted, on the basis of your work, then you don't have a claim of retaliation. My not being a nice guy to you is not enough to claim retaliation, again, unless you can tie that directly to some adverse action. There have been a number of situations where an employee takes an action, or an employer takes an action against an employee, realizes that they made a mistake and corrects that, either because they realized it or because an attorney or a court said, hey, you need to correct this mistake that you made. And you reverse all of that. You reverse a suspension, or you reverse a job change, or you still, you make them whole. They don't suffer from anything. The action itself still can be seen as being retaliatory, and they still can bring a case against you for retaliation if they can, by that, show that there was some adverse action. So the fact that you went ahead and made a change, reversed an action that you took, and you make the employee whole, if for a period of time they could show that there was an adverse action, it cost them money, it cost them reputation, it cost them job opportunities, even though you've tried to reverse all that, you can still be claimed to have engaged in some retaliation against them. There does have to be some causal connection between the protected activity and the adverse action. They have to show that they did something, the employer responded to that and engaged in some action against them, that demotion, that lack of increase, that poor performance evaluation, all of those were that they were tied together. They can either do that by direct proof, or they can prove it through circumstantial evidence, and I'll give you a couple examples of that right here. Direct evidence can be something written in a memo, something written in an email, where the supervisor or manager made a comment such as the person was a problem employee who needed to be counseled about her work, when in reality the previous performance evaluations had shown that that person was not a problem employee, was not having difficulty at work, that their previous performance evaluations had been at least acceptable, if not above that. That's why a lot of times you'll have, when you go to a human resources person and you say, hey, I want to get rid of Joe here, and the HR person says, well, why do you want to get rid of him? That there is evidence, and the supervisor says, well, the person is a poor performer, their attitude is bad, and the HR person says, well, let's go back and take a look at the previous performance evaluations. And you go back and look at that evidence, and you find out that on the last performance evaluation, the person was given an average or above average performance evaluation, that the quality of the work that they're good was good, their attitude was good. And at that time, the supervisor says, well, I was just being nice. I didn't want to give the person a bad performance evaluation because I'm a nice guy. And the HR person looks at you and go, well, basically you screwed yourself by not being honest on another performance evaluation. And you can't do that if you've and particularly if the person can then show that I've been a good performing employee up to this point where I made a complaint about my manager's behavior. Either the way my manager was treating somebody else, the way my manager was treating me, the manager was doing something that I thought was not ethical, and I made a complaint. And then from that point on, suddenly, I'm no longer a good employee. I'm a problem employee. That course of action right there, going from being a good employee to having made a complaint to now being a bad employee, is direct evidence of that kind of retaliation for that complaint. Again, that complaint may have never surfaced as an actual complaint to the EEOC or the wage and hour division or OSHA or anything. They just made the complaint to the supervisor, but now as a result of having made that complaint, they're no longer the model employee that they had been prior to that. That is direct evidence of potential retaliation. The indirect evidence is things like timing of statements, the fact that after having made the complaint, the employee is now being treated differently from other employees. The fact that now, as a result of that complaint, the supervisor is now noting everything that the employee does. They're keeping a book on the employee. They're building a case. And it could be because HR said, hey, you can't do that. You've got all of this evidence in the file that shows that you thought this person was a good employee, and now what the supervisor does is starts building a case against that particular employee. Now, in some cases, that's something you do want to do. If you haven't done any documentation of somebody's poor performance or somebody's poor behavior, you do want to start keeping that. But you've got to be careful about doing that in conjunction with them having made a complaint about something. So if somebody is, like I said, been a model employee up to this point, and now they're suddenly complaining about something, now they're suddenly noting that their supervisor is doing something wrong, or they don't like the way their supervisor is treating them or a fellow employee, and now the supervisor is suddenly now keeping a lot of records about them, noting everything that they do wrong, the employee can take that kind of evidence and say, as a result of my complaint, as a result of my the timing of I made my complaint here, and then, the 2 weeks later, I'm now a bad employee, everything I do is wrong. That right there looks like you're building a case against that employee based upon the timing of their particular complaint, and that all to a judge, all to a jury, looks like potential retaliation. And that's what they build their particular case on. So you've got to be very guarded about suddenly flipping a switch on an employee who has been doing at least satisfactory work up to this point, and and then suddenly they're not being satisfactory. If in the intervening time of going from satisfactory to being unsatisfactory, they had made some complaint about something the supervisor said, did, or the way they treated somebody, that suddenly unsatisfactory behavior and extra documentation looks like it is retaliation, and it can certainly be interpreted that way. What are some of the things that employees are protected from? Number one, internally complaining about harassment or discrimination, of going to human resources and saying, hey, I wanted you to know that I saw this behavior occur between an employee and a supervisor. And that could be a supervisor comes in and puts his arm around a female employee's shoulders and gives her a hug or gives her a kiss on the cheek. Now, that may sound outlandish to you, but it has occurred, and it does occur, and sometimes it gets reported. And that's quite often, one of the things as a human resources professional, we will hear things from employees where employees will come up and say, hey, I wanted to tell you about something. I don't want you to do anything about it. I just want you to be aware of it. Unfortunately, HR is put in the position of saying, I can't not do anything about it. I've got to, if you're making a charge of something about harassment or discrimination, I've got to do something about it. So internal complaints of harassment and discrimination can be subject to harassment by a supervisor or by a manager as a result of any investigation is done. Sometimes it goes beyond internally and the complaint gets filed externally, where the first time you find out that somebody's made a complaint is you get a filing from the EEOC or an investigation from the DOL based upon an employee's complaint, and in many cases that may be the first time that you find out about it. And in that particular case, what happens is when some supervisors or some managers have a complaint filed against them, they get angry about it. They get personally offended by it. And as a result of that, they will take action against that employee who has made that claim. And, where they're, and again, as you recall at the beginning statement, that claim of harassment or that claim of discrimination may not have any finding in fact at all once it's investigated. However, the supervisor or manager have been in their eyes, defamed as a result of that, and many people will get upset at being claimed to have been discriminatory or a harasser, and as a result of that, end up retaliating at a later time against that particular individual. It is another case is where in an investigation, somebody goes to, you know, whoever's doing the investigation goes and talks to other employees, and another employee confirms what the person who has filed the charge has said, and the person who has been claimed against finds out that somebody has documented or has substantiated what the original filer said, then in many cases the supervisor or manager will become upset about that as well, and that is going to be you know, filed or particularly as a retaliation situation. Sometimes people just participating in an investigation can get somebody targeted by a manager or supervisor, where the manager or supervisor could come up and say, hey, they're probably going to come and talk to you about this. Don't say anything. And if I find out that you're saying anything, then there may be some consequences. Well, that act right there is an act of retaliation, that if that person ends up suffering in the job assignment or financially, you know, gets targeted for layoff, could all be tied back to the fact that that supervisor has threatened them just for having participated in an investigation. People who complain about work assignments or reassignments, if they can, if they end up suffering further as a result of that, that's also can be claimed as retaliation. And then certainly answering questions in a deposition, even though they're answering questions to an attorney, typically people will try to get them to put some pressure on them not to answer truthfully, and all of those can be deemed as acts of retaliation. Now this is a little bit of a dated survey, but it still holds fairly true, and it gives you an example of the kinds of things that can be deemed to be retaliation. 62% of complaints of retaliation were due to being excluded from decisions of work. So it's not just a matter of somebody being transferred, it's not just a matter of somebody being demoted. It is the fact that prior to that person's action, either a complaint or a claim of discrimination, they were included in making substantial decisions at work. Now they are no longer included. They are actually being excluded from that, and that has substantially changed their job because the fact that they're excluded from claims or from decisions now has an inhibitory effect on their career, an inhibitory effect on their pay, and they can claim that they have an adverse action taken against them. In many cases, shunning somebody who has been involved in this can be claimed to be retaliation. They're no longer included in discussions. People avoid them in the hallway. In many cases, they're not even acknowledged as being in the same room. They're not being introduced. Those claims right there can be claimed to be retaliation because now they're being treated differently as a result of something that they did before. 55% of people that have made these claims said that their bosses become verbally abusive to them, that they treat them differently than what they were being treated prior to their claim or participation in a claim. Some almost lose their job. Some said that they've been passed over for promotion or a raise as a result of filing a complaint. 42% said that fellow employees become abusive to them, that the rest of the department rallies around the supervisor and ends up demeaning, debasing, ignoring, abusing the employee who has filed some claim against the supervisor. In some cases, people have reported being relocated or reassigned. And this is, as I put up here, is very akin to being reassigned to a base in Alaska if you're in the military. You know, you're being sent someplace that is a less desirable assignment as a result of the action that you engaged in you know, reporting discrimination or reporting harassment. Some people, you know, almost 20% report that they've been demoted, and then in some, you know, small cases, 4%, some people have actually been physically attacked or even had their property vandalized, and that has occurred, I know, in a number of situations where people had gone out and at some point in a period of time after having filed a complaint, they find their car has been keyed or windows have been broken or mirrors broken off and that kind of stuff. So, you know, a lot of different things go into these kinds of acts of retaliation. Now, one of the ways you prevent retaliation to begin with is you prevent discrimination. You've got to make sure that you have a written policy that prohibits discrimination. The EEOC, the Civil Rights Act of 1964, specifically prohibits that, and that needs to be written into your policy. You also, on top of that policy that prohibits discrimination on the basis of all those protected categories, you also have to have written into that the fact that retaliation is also prohibited. And in that particular case, you need to do training with employees on that policy, specifically with supervisors and managers, so that they understand what discrimination is, they understand what they're supposed to do in reaction to it, and that they understand how their actions can be interpreted as being retaliation. So a lot of training is necessary in that. You need to have that form that allows employees to file an internal complaint. You particularly want to have the ability to have them file an internal complaint so that you can follow up on it and investigate it and take care of it and you know, nip it in the bud before it ever gets to the point of being filed to the outside. So good policy, good training, good follow-up, good investigation will help you probably not totally eliminate discrimination in your workplace, but certainly manage the potential for getting a charge of discrimination that can end up leading to having retaliation tacked onto it. Here are some of the steps that are necessary to conduct that investigation. Step one, be aware. Be aware that discrimination can occur in your workplace. Yes, you may not yourself participate in discrimination, but you may have, we as humans are inherently biased. They come built into us. They come socialized into us as we grow up. As you go through elementary school, middle school, high school, college, we end up with a whole slew of biases that so once we get into the workplace, we end up having those in it. So you need to be aware that people do have biases, and you need to make sure that you have the policies that make people aware that that's against your workplace policy. And then if you ever hear of potential discrimination, you need to investigate very quickly, and failure to do so is a very quick route to going to court. Step two is treat the person reporting the discrimination with respect. Many people are afraid to come and say something. That's why I, as a human resources manager, a number of times had people come to me and say, hey, I don't want you to do anything about this. I just want you to be aware of it, because they're afraid of the repercussions of having made that report. And as we're talking about retaliation, those fears are justified. People do get retaliated against for claims of discrimination or harassment. And like I said early on, their claim of discrimination or harassment may be unfounded. It may be a matter of interpretation, that once you do some investigation and you have some conversations, you may settle what was just a misunderstanding of something that was being said or something that was being done, that once you get that settled, you can take the discrimination or harassment aspects out of it, particularly in sexual harassment. Some of us, some people are raised in families where, they're huggers. And so, hugging another employee is just seen as a measure of friendship. But other families, other members, people were raised in families that have bigger personal space than that and don't like having that invaded. But if you come up and try to hug somebody, they don't like it, you could end up, if you continue that behavior, to be charged with harassment. But a discussion, if somebody's investigated that and you found that it's just a way, two different ways of socializing, in many cases you can put that to rest. The person who is the hugger just has to resist doing the hugging, and you have to help the person who is not the hugger understand that nothing was meant by that. That is the way they deal with everybody. So that's, that's the importance of doing that investigation. If your employees see that you're taking up their problems seriously, they are less likely to escalate it beyond the company, and that's one good way of avoiding getting into court. Step 3 is, don't be angry with the complainer. If you're the manager that's being accused of harassment, understand where the person's coming from. Don't be angry with that person. Don't retaliate against them in any manner, even unintentionally. And as an example, transferring somebody to another shift during an investigation could actually be seen as being retaliation for them having made the complaint in the first place. Try to avoid doing that kind of thing. Step 4 is follow your established rules. Don't get accused of treating someone differently than others as a result of their complaint. Interview people involved. Interview the person that filed the complaint. Interview the person that was accused. Interview any possible witnesses, and make sure you're getting your details on paper. What was done, what was said, when, where, who else was involved, who else was there to witness this. Make sure that that's all being documented. And you need to have that on a piece of paper rather than just in your head. I have an attorney friend of mine say one time that she would rather have 1 page of documentation versus 10 pages or 10,000 words of testimony. So if it ever goes to court, people believe what's on paper much more often than they believe what is said. Step 6 is look for corroboration or contradiction. In many cases, you will have somebody saying something was done on this date, and you may need to get into the records, the time cards, emails to see what was being said at that date. Was the two parties involved actually even present at work on those dates? Take a look at any supervisor's notes to show whether they had any conversations with those employees. Whether was this a case of you can find evidence that shows that the supervisor had actually disciplined an employee at that particular time, that the reason for discipline was justified, and that right after that discipline is when a complaint surfaced, and the complaint seems to be related more to the discipline and the act of having been disciplined as opposed to some act that a supervisor took that was discriminatory or harassing. So you need to go in and take a look at that evidence, and that's one of the reasons that in your training with supervisors, you want to make sure that they understand the importance of documenting all of their steps as well, their conversations with employees. Step 7 is keep it confidential and insist on confidentiality if you can. In some cases, particularly if you are in a union environment, it is under Section 7 of the National Labor Relations Act, employees actually have a right to be able to share information about their wages, hours, and working conditions. And since a harassing supervisor is considered a working condition, if they want to share that with other employees, you in reality cannot stop them from doing that. You can certainly argue to them that it is important for them to be able to, for you to be able to corroborate stories without interference from other sources, but you can't insist on or absolutely demand confidentiality. If they really want to be able to share that with somebody else, then they have the right to do so, and you can actually now get in trouble with violating the National Labor Relations Act and trying to prohibit them transmitting that information. But it's good if you can try to impress upon somebody the necessity of confidentiality, and until you've completed your investigation so that you can get proper information, you can do a proper investigation. If you can convince them that it's important to try to not be spreading information around, that's a good thing to do. Step 8 is document, document, document. Write it down. Keep that journal. Write those steps down. Take down what you consider to be the truth. Include your dates and your places. Write down all the names of people who you have talked to. Write down the names of the documents that you reviewed. And then document any action that was taken against the accused or against the accuser, and any action that you may have decided on taking or not taking. Again, this goes back to what my lawyer friend said. She would rather have one page of documentation rather than 10,000 words of testimony. Is you need to have this information documented. It will protect you in court. One of the reasons lawyers hate claims of retaliation is typically they will have helped you go through all of the claim of discrimination. But a lot of times what happens is retaliation occurs long after the act, long after the complaint. It may, some supervisors or managers or companies don't take any action against an employee for months, maybe even a year, the next time that performance evaluation comes up. And in that particular case, there are a lot of times is not the documentation that needs to be done. So one of the things that you need to do is go through and ask yourself a lot of questions to help prevent any retaliation. Do you have the policies? Have you covered it with everybody? Have you made sure that you've got a strong anti-retaliation statement? Do you have a complaint process that employees are aware of and understand and can follow? Do your employees know to whom and how to submit complaints? Do you have a way for them to be submitted, in a non-face-to-face kind of situation? Have you trained all your supervisors and managers on your anti-retaliation? Do you have a department that is designated to handle those complaints? Do you consistently and fairly implement a disciplinary action? Are you keeping all that documentation of employee performance? A lot of companies today are getting away from doing performance evaluation, performance appraisal, and in some cases that may be a good thing, but from a protection standpoint, proving a case, proving that you have not illegally discriminated, that kind of documentation is going to hurt your case if you do not have it. So keep those records and retrain supervisors who engage in retaliation. Do you provide the same kind of information on references for all former employees? And you need to ask yourself, do I have a situation where retaliation could exist? is the employee raising informal concerns with the supervisor? Is the employee threatening to file a complaint? Has the employee filed a complaint? Has the employee gone to the outside, or is the employee supporting a coworker who's filed a complaint? Those are all situations that could end up resulting in retaliation against them by a manager or supervisor who has been the subject of that particular complaint. Is there any further action? A year from now, is this person going to be up for a promotion? And if we don't give them that promotion, then what are the consequences of that? How are they going to view that? Has the employee left and asked for a letter of recommendation or reference, and you have opted not to supply that to them, even though their performance was good prior to them having filed that complaint? They may have made the decision that it was no longer tenable to work at this particular organization, and now they're looking for that reference. And if you opt not to provide that to them, not on the basis of their work, but on the basis of that complaint, then you are engaging in retaliation, or the supervisor is. So you need to have a policy on how recommendations are given out and by whom. Are you treating people differently on the basis of either their performance or their actions of having filed a complaint in the past? So if a retaliation complaint is received, you need to determine what the date of the employment action was compared to the date of the protected activity. So again, that's a timing kind of issue. It is if somebody filed a complaint against a supervisor, and then a week later they're now demoted, or a week later there's now a recommendation that they don't get an increase, that looks kind of suspicious. So you've got to be careful about that. If on the reverse, the employment action was taken prior to them making a complaint, then that looks like it's more like the employee's complaining about that action, as opposed to a reverse retaliation kind of thing. If indeed the employee has had past performance problems, then you need to make sure when, where, and what was being done, and you need to take a look at how employees in similar situations are being treated. Are they being treated differently, or are they being treated the same? And if the person who made the adverse employment action decision was aware of any concern or complaint from the employee that that there was some discrimination or other unlawful activity going on, if that action by the person follows that claim of discrimination or unlawful activity, then you've got a good potential of having a retaliation complaint. So all that investigation, that takes good investigation skills to be able to do that, things that you need to take a look at. It is good to have ongoing training for your supervisors, for your managers, to consistently remind them not only of what discrimination is, but also what retaliation is. And so with that, we'll come to a close. I know I haven't left a whole lot of time for questions, but discrimination may lead to retaliation. Retaliation is considered to be as bad as any discrimination. Discrimination does not need to occur for retaliation to occur. Both need to be investigated promptly. Appropriate discipline needs to be meted out, and then all actions need to be documented. And with that, Kishore, we will come to an end and ask if there are any questions, and I'll be happy to answer them if we put those in the chat box.
Yeah, thank you, Michael, for the presentation. Now we will open the lines for Q&A section. Anybody having a question can raise their hand by clicking hand button, which is down right corner of your screen. Also, you can send your questions in the chat window. I think it seems there is no questions at this moment. However, you can still send your questions through email ID at webinar@compliancekey.com. With this, we will end the session. We appreciate your time and believe the session was informative and up to your expectation. We look forward to see you in your next event. Soon, you would be receiving certificate of attendance and a feedback form. Kindly send your comments. Your feedback is important for us. Thank you very much for your time and have a good day. Thank you, Michael, for the presentation.
Thank you, Kishore.